I am recording.
Hi, thank you, Zakiswa. Thank you for confirming. Yes, and also first and foremost, good evening to everybody. So we are going to focus on the structure of Bill of Rights litigation. There's basically mainly three stages. It's procedural, substantive, and remedial. The procedural stage is broken down into three substages. So first of all, application, then justiciability, and then jurisdiction. And then the substantive stage has also got some subsections, but let's focus first on procedural. So application. So does the Bill of Rights apply between the relevant parties? Is the respondent bound, and is the applicant protected? Sorry. And in terms of application of the rights in the Constitution, we always look towards Section 8 that provides for the application of the Bill of Rights, both horizontal and vertical application, and then also you should know the distinction between direct and indirect application of the Bill of Rights. Bill of Rights, justiciability includes a few concepts. First and foremost, standing or locus standi. That is dealt with in Section 38 of the Constitution, and we're quickly going to have a look at concepts such as ripeness and mootness, and you'll also see that these concepts are discussed in your guide. Jurisdiction, very important in terms of litigating constitutional rights, which courts can hear the relevant matters that's being brought before it if it contains a constitutional aspect. The substantive stage is when we're now in front of the courts, we are litigating our rights. You should be aware of the interpretation clause and obviously the limitation clause, and that's part of the substantive stage. So procedural would be application, justiciability, and jurisdiction. Substantive is interpretation and limitation, and then obviously remedy. In terms of remedy, and what we'll be focusing on in this lecture in terms of remedy, is specifically the remedies that's provided for in terms of constitutional rights and in terms of the Constitution itself. And that's mostly focusing on two sections of the Constitution, which is Section 38 of the Constitution and Section 172 of the Constitution. So the purpose of this evening's lecture is we are going to focus on the specific provisions in the Constitution that deals with these specific aspects. In other words, when we are litigating our fundamental rights before our courts. And so we are going to start off with the procedural stage, the first leg of the procedural stage, and that's application. So who is protected by the Bill of Rights? Is the applicant entitled to a particular right? And first and foremost, obviously, we look towards the text of our rights. Most rights in the Constitution is applicable to everyone. There's only specific rights that's reserved for citizens, such as the right to vote. Certain rights are only applicable to children as well in the Constitution. But most rights in the Constitution is applicable to everybody. In terms of application as well, you should be able to distinguish between direct application and indirect application. So I'm not going to go into too much detail in terms of Section 8 of the Constitution, but it provides Section 8.1 for direct vertical application. So if you think about vertical application, this is the application of the Constitution that binds the state. So the text says it binds the executive, the legislature, the judiciary, and all organs of states. Okay, Section 8.2 provides for horizontal application. So it means all of us is also bound by the Constitution, obviously to the extent that the right is applicable, taking into account the nature of the right and the duty imposed by the right. And then also you'll find that Section 8.4 of the Constitution provide that juristic persons are entitled to the rights in the Bill of Rights, also dependent again on the nature of the right and the nature of the juristic person. For example, if you think about it, a juristic person won't be able to claim the right to life. But for example, if you are a publishing house, you will be able to lay claim to the right to freedom of expression. So it's dependent on the nature of the right and the nature of the juristic person. Important fact about direct application is that when the Bill of Rights is directly applicable, it would override the common law rules or legislation which are inconsistent with it, and the remedy will be a constitutional one. So your remedy is a constitutional remedy, which is different from the indirect application of the rights in the Bill of Rights. So we know that the interpretation and indirect application is regulated by Section 39 of the Constitution, and it refers to interpretation, development, and application of legislation and common law by every court, tribunal, or forum in a way that respects the values of the Bill of Rights and promotes its purport, spirits, and objects. So in other words, ordinary law is infused with the values that underlie the Bill of Rights. But there's obviously sometimes limits to direct application, so legislation cannot always be interpreted to comply with the Bill of Rights, and common law can only be developed on a case-by-case basis as well, and may also be hindered by the doctrine of stare decisis. What's important here, which makes it different from direct application, is that the remedy is not a constitutional remedy in terms of direct application. Sorry, just wanted to show you the slide before. So it's different towards direct application, where your remedy is a constitutional remedy, whereas where the Bill of Rights or the rights in the Constitution is indirectly applied, your remedy would be in terms of the specific piece of legislation or the specific rule of common law that is dealt with in that specific instance. Indirect application goes hand in hand with the principle of subsidiarity, or what we also know as the principle of avoidance. So in terms of the principle of avoidance or subsidiarity, it means that we always prefer, firstly, the indirect application of the rights in the Constitution before we prefer a direct application. So before we declare something as being unconstitutional, we'd rather see if we can interpret a piece of legislation or a rule of common law using the values that underlie the Bill of Rights before we strike something down as being unconstitutional. You'll also find that in terms of the Constitution, there's a lot of rights, and I provide a couple of examples there, that calls for legislation to be enacted to give effect to those rights. If we think about Section 9, in terms of Section 9, we now have the Promotion of Equality and Prevention of Unfair Discrimination Act. It's the same for Section 32 with the Promotion of Access to Information Act and several other rights. So where those pieces of legislation exist, we are not going to jump first and foremost to, if we think a client's right has been infringed, we're not going to jump first and foremost to the relevant section in the Constitution and lodge application to enforce their constitutional right, but we are first and foremost going to apply the specific and applicable piece of legislation. So where there is legislation that exists, the right should not be invoked directly in terms of the Constitution, but you find recourse through the relevant statute. So the principle is, first, before we want to declare something as being unconstitutional, we first have to see if the Constitution can be indirectly applied. So can we interpret the relevant piece of legislation or common law to be in conformity with the Constitution? And then obviously my remedy would be in terms of that legislation or common law before we jump to the Constitution directly. So that is basically the first leg that we've just done, procedural application. If we want to know if the Bill of Rights is applicable, we look towards Section 8. Basically, in a very short, sort of concise sentence, what Section 8 provides to us, as you've seen, is that the Constitution and the Bill of Rights is applicable to everybody. It's applicable to the state, it's applicable to me and you, it's applicable to juristic persons as well. And then obviously in terms of litigating our rights, Also be aware of the fact that there's a difference between direct application and indirect application. And in terms of the principle of avoidance and subsidiarity, we always attempt indirect application before we jump to the direct application of our relevant rights. Is there applicable legislation that governs a specific right, then we would find recourse through that specific piece of legislation first and foremost. Our second leg of the procedural stage is justiciability or standing, which is also the most important part under justiciability. Is, do you have standing to request a particular relief that you are seeking? We used to follow a very narrow approach in terms of that if you wanted to litigate, you needed to have personal interest in the matter, but this has now been changed with our Constitution and with specifically with Section 38 of the Constitution, and we now follow a very broad approach to standing. So in terms of the section of the Constitution, there's 5 categories of people or litigants that will have standing to litigate their fundamental rights. And very importantly, in terms of all 5 of these categories, therefore, you don't need to have personal interest anymore, but the catchphrase is now sufficient interest. I can hear somebody's mic, so if you just don't mind muting your mic, please. Sorry, guys, let me just see if I can trace this individual and just mute it for them. There we go, that's better. All right, so we're getting back to standing and the groups that would have standing. So obviously first is the old common law position, so acting in your own interest. So that's when you've got personal interest in the matter. The second one is persons acting on behalf of another person, and there's many reasons why you won't be able to act in your own name. For example, you're a minor. The requirements is consent from the person, or if you cannot obtain consent, it has to be clear from the relevant circumstances. Person acting as a member of a group or a class of persons, so-called class actions. So you're not only acting for yourself, but all people similarly situated. When you act in the public interest, you must show that you act in the public interest and prove that the public has sufficient interest in the remedy. Again, the concept of sufficient interest as opposed to personal interest. And then also an association acting in the interest of its members. The members must have sufficient interest. So again, you can see, as with Section 8, that basically makes the Bill of Rights applicable and the Constitutional applicable to everybody. Section 38 allows for a very broad category of people to enforce their rights and to have standing before the court, before the courts. Part of justiciability is concepts of ripeness and mootness. It's also referred to in your guide, but I'm just very quickly going to brush over it. I think in terms of justiciability, the most important aspect is standing. But ripeness just refers to is the concept that you need to avoid premature litigation. So you shouldn't bring a matter too early. The issue must be real and not hypothetical. The applicant must be sure that the court can grant concrete relief. Now, mootness is almost just the opposite of ripeness. So it prevents a court from deciding an issue when it's too late. So it should be present and existing and live controversy. All right, so ripeness, don't bring it too early. Mootness, don't bring it too late. That's the bottom line of the two concepts. The last part of the procedural aspects is jurisdiction, which is quite important, and especially the guide places a lot of emphasis on this as well. You're more than welcome to have a look at the guide. It's from page 38 onwards. And as we all should know by now, the Constitutional Court's jurisdiction have changed. It was in terms of the Constitutional Court Amendment Act of 2012. Previously, the Constitutional Court could only hear matters, constitutional matters, and now the Constitutional Court is the highest court in all matters, and not only just constitutional matters. So what does the text provide for? So the Con Court is now the highest court of the Republic and may decide, obviously still, constitutional matters and any other matter if the Constitutional Court grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance, which ought to be considered by the court. So still the court will not allow, and they're very strict, so they're not going to allow just any matter to be heard by the court. And remember, obviously, the Constitutional Court is an appellate court, so it needs to raise an arguable point of law of general public importance. It makes the final decision whether a matter is within its jurisdiction. So that is just something important to take note of, is the change in its jurisdiction and the matters it can hear. And yes, I've read recently, yes, that the court's load obviously with this has increased tremendously, and that there is struggles with the court in terms of getting their judgments out now in time. There is quite a delay in judgments that needs to be handed down. Etc. So this amendment has placed increasing pressure on our Constitutional Court, and they have come under scrutiny for that quite lately, for the fact that the judgments are not coming out as quick as they should be. Yes, is there a question?
Yes, Prof. You said that the Constitutional Court is an appellate court.
Yes.
But also appellate and apex.
Yes.
Yeah.
But
and
apex court in the sense that
court of first instance.
It can be a court of first instance. We're going to get there in terms of direct access. But direct access is very difficult to obtain from the Constitutional Court, and it has stated on numerous occasions that it does not want to sit as a court of first and final instance. So the Constitutional Court prefers that you follow the route of the normal route in terms of being an appellate court, of first going to the High Court, then to the Supreme Court of Appeal, and then to the Con Court. You can get direct access, and we're still going to look at the factors in terms of how do you obtain direct access, but it's very difficult to get direct access to the Constitutional Court.
Okay, thank you.
Ma'am,
yes.
Can I say, am I correct to say, unless if the matter is against the Constitution itself, therefore it can be a direct access, correct?
Oh, it depends on the matter. It's not to say that it needs to be restricted to a constitutional matter only, because we now see that it depends on, because its jurisdiction has been broadened, arguable point of law and a law of general public importance. So we'll see what the requirements. I think you're jumping the gun a bit. So let's just see what the requirements are for direct access. But yes. You can go to the Constitutional Court and obtain direct access, but as I've mentioned, it is a very difficult hurdle to have to jump over to get the Constitutional Court to hear a matter as first and final court. Is it fine if I continue? Any further questions so far?
You can continue, Prof.
Thank you so much. All right. So that is Constitutional Court jurisdiction. We also know in terms of section 1674. Yes, is there a question?
Yes, Prof.
Yes.
I just find out you made a remark to the effect that if a matter is being dealt with and it also concerns a constitutional matter, and there is a statute which addresses that particular matter, that we shouldn't jump straight to the Constitution, that we should first seek redress with the provision of the statute. Is that correct?
That is correct, yes.
Okay.
So, for example, if you, let's just take the Equality Act, and, for example, Section 9 of the Constitution, if you feel, or if a client feels that they've been unfairly discriminated against, the recourse would be obviously first to first approach the equality courts in terms of the relevant equality legislation, because there's specific remedies provided therefore. So if you feel that you're being discriminated against on on a relevant ground, you're not going to jump straight to the Constitutional Court or to the High Court to find relief. Obviously, you're going to find recourse through the relevant piece of legislation that provides for specific remedies in that regard.
So reference to provisions of the Constitution should not be made, is that what you're saying? Or rather make reference to the provisions of the Act itself?
You would first seek recourse through the Act, and then possibly, but also, I mean, if the Act doesn't provide you with the relevant remedy, or if you are challenging, sometimes you would challenge provisions of the Act itself, then obviously, then you would find that you would directly rely on the relevant constitutional rights. But in South Africa, we follow the principle of avoidance, where you first apply indirectly before you apply directly. And you also see first, is there any applicable legislation that gives effect to my right in the Constitution? If there is, I first need to go see and seek recourse through the applicable legislation instead of just jumping straight into a constitutional challenge.
Right, thank you.
It's a pleasure. All right, exclusive jurisdiction. So the ConCourt also has exclusive jurisdiction, which means that only the ConCourt would hear these matters, and it's 6 matters. It's disputes between organs of states regarding the powers and the functions of those organs, the constitutionality of a parliamentary or provincial bill that is subject to Section 79 or 129, or sorry, 121, applications in Section 80 or 122 of the Constitution, decide on the constitutionality of an amendment of the Constitution, decide whether Parliament or the President has failed to comply with the constitutional duty, or to certify a provincial constitution. So only the Constitutional Court has jurisdiction over these relevant matters. Also, something to take account of is Section 1675 of the Constitution. That's important. The Constitutional Court, makes the final decision whether an act of Parliament or provincial act or conduct from the President is constitutional, and must confirm any order of invalidity that was made by the SCA or the High Court or a court of similar status. So if the High Court or the Supreme Court of Appeal declares a piece of legislation as being invalid and as being unconstitutional, that needs to go to the Constitutional Court for confirmation. And then obviously the Constitutional Court can come to a different finding as well in relation to the relevant matter. So anything that's declared unconstitutional goes to the Constitutional Court for confirmation. The Constitutional Court, as we know now, does not have exclusive jurisdiction in most cases. So it's got concurrent jurisdiction with the Supreme Court of Appeal and the High Court, subject, of course, to the power of the Constitutional Court as the highest court in all matters to overturn their decisions. So this may happen on appeal or when it is sent for confirmation as per Section 1675, which I've just referred to. Then the SCA, under the same Amendment Act, there was also certain amendments made to the SCA's jurisdiction, previous jurisdiction, and as well as the High Court jurisdiction that set out. So the sections differ a bit from what was previously provided for. And just make sure, because a lot of us still have these little pocketbook constitutions. So if you still make use of a little pocketbook constitution that you've got somewhere at varsity or obtained, sometimes they used to hand them out at schools, make sure that you've got the one that's got the latest amendments, or if not, just make sure that you're aware of the fact that the Constitution has been amended and that these, for example, these specific sections have changed. So Section 168, Supreme Court, the SCA may decide appeals in any matter arising from the High Court of South Africa or a court of a similar status to the High Court, except in respect of labour or competition matters to such an extent as may be determined by an Act of Parliament. So now specifically, obviously providing then for the Labour Appeal Court and the specific competition tribunals, which have their own forums. And the Supreme Court of Appeal may decide only appeals, issues connected with appeals, and any other matter that may refer to it in circumstances defined by an Act of Parliament. So that is the SCA's jurisdiction. High Court, sections 169. The High Court may decide any constitutional matter except a matter that the Constitutional Court has agreed to hear directly. So there's the direct access again in terms of section 1676A, or it is assigned by an Act of Parliament to another court of a similar status to the High Court, and any other matter not assigned to another court by an Act of Parliament. So that is the High Court's jurisdiction. And then obviously our match courts, are they allowed to hear any constitutional matters? Section 170 provides that a court of a status lower than a High Court may not inquire into or rule on the constitutionality of any legislation or any conduct of the President. So obviously they don't have constitutional jurisdiction. It's the High Court, Supreme Court of Appeal, and the Con Court. An important section is section 110 of the Match Court Act. So where a party to proceedings in a match court allege that any law or conduct of the President is unconstitutional, the court must decide the matter on the assumption that the law or conduct is valid, and then the litigant should raise the constitutional issue on appeal to the High Court. But I trust that all of us know that we should not raise constitutional issues in match court papers, as obviously then section 110 would be applicable. It would be decided as if it is valid, and then you need to go to the High Court in any case on appeal. Can the match court develop the common law in terms of section 39.2? No, again, they're not included. The only courts that can develop the common law is again our higher courts, Supreme Court of Appeal, and constitutional courts. Why? Because of the doctrine of precedent. But still, it does not mean that these courts are not bound to uphold and give effect to the Constitution and constitutional rights. So in a nutshell, that is jurisdiction. So obviously take note, and you'll see it's mentioned in your guide quite prominently as well, the change in the Constitutional Court's jurisdiction as any other matter if it raises an arguable point of law that is of general public importance. All right, now we can jump to direct access. So section 1676 of the Constitution provides that national legislation or the rules of the Con Court must allow a person, when it is in the interest of justice and with leave of the Constitutional Court, to bring a matter directly to the Constitutional Court, and you'll find that in Rule 18 of the Con Court Rules. Appeal directly to the Constitutional Court from any other court, and that is Rule 19. So direct access will be granted in matters over which concurrent jurisdiction is exercised, and if the matter of such public importance or urgency that direct access will be in the interest of justice. So as I've mentioned before, the court is very strict on granting. It will refuse direct access because of the fact that it does not want to sit as court of first and last instance, especially in matters which deals with the with the common law, especially because the Supreme Court of Appeal is seen as being the expert on common law and the development of common law. So obviously they would like the input from the SCA first before they make a final decision on the relevant matter. So it's very difficult to get direct access. And obviously, in terms of getting direct access, it's something when you litigate and you provide advice to your client, you really need to think very carefully about it if you think to attempt direct access, because it can be a very expensive exercise to advise your client, oh no, you think that direct access to the Con Court is the way to go because this is a constitutional matter, it's a strong constitutional case. And then the court refuses to hear the matter as it's not in the interest of justice to do so, and it means a hefty costs for your client that's incurred then. So direct access is really for matters that's of the utmost importance and in the interest of justice. And even then, you need to consult with your client, as there might be, it's very highly likely that the ConCourt would not hear the relevant matter. So just be careful of it. In terms of the guide, I like page 41 of the guide, gives a good outset of direct access, and it refers there to the Economic Freedom Fighters case versus Gordon and others and the Public Protector. And basically, again, the ConCourt in that case confirmed that direct access is, first of all, discretionary and when it's in the interest of justice. The court referred there to a non-exhaustive list of factors of what it is to be, what would be considered to be in the interest of justice. First and foremost, the importance of a constitutional issue that's raised, the potential of irreparable harm if leave is not granted, whether the interim order has a final effect, are there prospects of success in a pending review, and deciding an appeal against an interim order. Would the appellate court usurp the role of a review court? Would interim relief trespass on the terrain of the other branches of government before the final determination of review grounds? Would the appeal lead to piecemeal adjudication and prolong the litigation, or lead to wasteful use of judicial resources and legal costs? To advance a new case on a different basis on issues not advanced in the High Court and Supreme Court of Appeal under the guise that it is in the interest of justice is not acceptable. The respondent should have a chance to represent their case. And as I've mentioned, the court is very skeptical to be a court of first and last instance. So before we move on to interpretation, is there any questions that you have on jurisdiction? Any questions on jurisdiction? All right, if it's in order, my power is just about to switch back over. So just please allow me the quick 10 minutes so that I can just quickly switch over. And then it is now, according to my watch, 6 minutes past 6. So let's be back just after 1:15 if that's in order.
Hello, Prof.
Yes.
I just want to ask a question because there's something I've been struggling to understand.
Yes.
There's this reference they make in a case law where they said the case is quoted with approval. What does it mean?
Which case has been quoted with approval?
Like, say, for instance, a judgment has been handed down, and in that judgment, a reference to a specific case is made, and there is a reference to that case that said it is quoted with approval.
It's quoted with approval, meaning that the current court agrees with the relevant judgment of that court.
Okay. Thank you.
It's a pleasure. All right. I'm quickly going to switch off and I'll see you guys back in 10 minutes.
All right.
Hi guys, while waiting for ma'am, can I please pose a question? I just need to find out, do you guys have access to all the videos that are being recorded?
I only saw one for CCP.
Only 1 out of 5 days.
Yeah, that was the only one that I saw.
Oh, okay. Yeah, I think we need to consult with Zukisa to distribute them, or maybe to let her tell us where we can find them on YouTube, if they are stored on YouTube.
I put them on the group that we have on WhatsApp because I got all the videos of the CCP on my e-leader.
All of
All.
them?
Yes.
How
Then
did
that
you
means
manage to?
where are they loaded
Which
for these
tab are they
videos?
loaded?
They are under CCP, under the LSSA.
2023.
Yes.
Okay, let me check.
CCP 2023, because I saw the CCP, but there were old videos there.
I saw those parts. I even shared them on the group.
Oh, for 5 days.
Yes.
I've got only the videos for 4 days on the e-leader.
Because I don't see the need for recording if they
Oh,
can't
yes,
distribute.
they are there.
Are they
are
there?
Yeah, they are there. They are all loaded under CCP.
Oh, lovely.
By all means, for all the full 5 days, because someone just claimed that they recorded for 4. For the full 5 days, let me just count.
That's for a full 5 days.
Under which folder? Under which folder are they?
Let's wait for Anna. She's to respond because she's counting and checking.
Oh, okay.
Didn't we
attend
CCP for 4 days? I think
Yes,
it was
it's
4
4
days,
days. Yeah, they only uploaded 4. They are under that folder. Just share the screenshot.
Monday, there was no class. So we had class from Tuesday to Friday.
Yeah, they are
Oh, on
only 4.
Monday,
Well, which folder is it?
Wait, what mean that Monday there was no class? LLSA UNISA Online 2023. And then once you are there, you click on CCP lecture on your left. And then
ALSA.
Yeah, 2023 semester 1. And then on your left, down, there's CCP lecture. And then the videos are there. So they're from the 7th of February, not the 6th. Yeah, because I only see 4 here. There's only 4 uploaded. Attend, Anna. How many classes did you attend last week?
I think it was 4.
It
because
was
we
4
started on Tuesday.
classes, guys. We didn't have class on Monday.
I've attended 5 classes from the 6th of February.
Was it from the
This
6th?
is Monday.
We had a class.
We had a class on Monday, guys.
Yes,
class on
we did have
Yes.
we did have a class on Monday last week.
There was a class on
Anna,
Monday.
Anna, can you please share
We
the
had class
folder
on Monday.
name on the chart, please? Because I don't see it here.
Yeah,
Only
the
the
whole
folder
week.
name.
It was
Class on
the whole
Monday.
week.
It was the whole week, yes, Francis.
There's only
Yes,
four.
the whole
There's
week.
It
only
was the
four
whole
on the
week.
guiding.
It was Monday to Friday.
Yes, we
Yes.
have lectures Monday to Friday.
Yeah.
But there's only four. There's only 4 guidings posted.
Then that Gisa did not upload the other one. It doesn't mean that the class did not happen.
Yeah, no, we had 5. We had 5 classes
Yes.
last week.
Oh.
But there's only 4 videos posted.
That
Yeah,
is what doesn't make sense.
Yeah, maybe we should
Oh,
just
yes.
alert. We should just alert Uzuki to upload the 5th one.
It should have been recorded
Guys,
in class.
those
Yes, sorry,
recordings,
my bad. It was 5 days. Yeah, sorry.
hello, those videos were I think were posted there based on the slides that was posted on the announcements. That's why
Is it videos or is it slides, guys?
Like, honestly.
Videos, but it's videos, guys. It's videos.
Okay, so because there was no slide on Monday, supposedly, that means that the video cannot be captured?
There was a slide
No, we
on
did
Monday.
have a
There
slide
was,
on Monday.
we had slides for every day for the whole week.
Then that means it's not a reason enough for them to not have uploaded it.
But the
Yeah.
other thing, yeah, good
Maybe it's
afternoon.
just an error.
I think the other thing that I see is that there's one audio. I'm not sure if that audio covers a day. So what I see, there are 4 videos and one
one
audio.
audio.
So
Okay.
what could be possibly the case is that one day could have been recorded via video,
That's what
audio,
I
and
say.
then the rest.
We will ask the court to take into consideration.
So you're saying that it's audio that was not
we will now be basing this on what is called set down. Please visit it, read it at your own leisure. Beyond our time, I don't think we have questions, and I think we can close our session here. Thank you very much. Thank you.
Is the class finished? Is the class done now?
No, there's someone who's playing the video on the background.
No, the class is not finished. I'm back, guys. So we can all quiet down. And then we can start off again. Okay, thank you guys, and thank you for allowing me just to do the quick switch over. We are back with constitutional law practice. I am going to share my screen again, so just let me know as soon as it's visible and that you're able to see.
Yes, we can see the screen.
Thank you so much. Let me just go into presentation mode. There we go. Okay, so that is, as I've mentioned, jurisdiction. And as we just finished off with direct access. So, and that is obviously the first procedural, the first section of in terms of the bill of litigation, structure of litigation, application, justiciability, and jurisdiction, which is the 3 first steps. The second we are going to move into now, which is interpretation and limitation. So you're now before court, and obviously if you litigate constitutional rights or your fundamental rights, you need to know how the courts would interpret these relevant rights in terms of litigating before the courts. Let me just get to the correct slide. There we go. So obviously have a look at the text of section 39 of the Constitution. The aim of interpretation is to ascertain the meaning of a provision in order to establish whether law or conduct is inconsistent with that provision. It involves 2 stages. First, the scope of the right must be determined, and then you must determine where the challenged law or conduct conflicts with this right. Just take note, there's lots of methods of interpretation, you know, textual, contextual, historic, etc. But the preferred method of interpretation of the Constitutional Court is the generous and purposive method of interpretation, and especially with purposive, it is a method of interpretation that gives expression to the underlying values of the Constitution, which is equality, dignity, and freedom. However, as you know, there are several approaches to interpretation of the Bill of Rights, but these are all very theoretical, so I'm not going to go into too much detail. So you should know about the interpretation of the Bill of Rights. You should know that the preferred method of interpretation by the Crown Court is the purposive and generous method of interpretation. And obviously with anything, you always start with the textual. So you first look at the relevant text of a right, of a piece of legislation, and then obviously you would go on from there. So you should be aware of interpretation, the applicability of Section 39 of the Constitution, and the next leg of the procedural stage is, of the substantive stage is the limitation of rights. We know that rights are not absolute, that rights can be limited, and in terms, and you'll also see that this is prominent in your guide, is the application of the limitation of rights, which is Section 36 of the Constitution. So the limitation inquiry involves two main questions. First, is there a law of general application? And then you move over to what is known as the proportionality test. Is it reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom? And to ascertain or assist with this proportionality test, Section 36 has those 5 factors that should be taken into account when determining whether a limitation is reasonable and justifiable. All right, so the first one is general application. The rule of thumb there is it is met whenever a rule is accessible, when it is precise and not applied arbitrarily or in a way that discriminates unfairly between persons or groups of persons. And then the proportionality test with those 5 factors. Section 36(1)(a) refers to the nature of the right. Here the court has to assess the importance of a right. Then the importance of the purpose of the limitation, where the purpose does not contribute to the values of the Constitution, it cannot be justifiable. The nature and extent of the limitation, the court needs to assess the way in which the limitation affects the rights concerned, and there the following question should be asked. Is the limitation a serious or relative minor infringement of the right? And then also lastly, the relation between the limitation and its purpose. There must be a causal connection between the law and its purpose. Sorry, number 5 is the last one. And there's the less restrictive means to achieve the purpose. Limitation of a right must have benefits that are proportionate to the cost of the limitation. Still the best example, and also to see how the court really applied these 5 factors, is one of the first judgments of the Constitutional Court, the S versus Makwanyane judgment, or the Makwanyane judgment in which the court had to decide on the death penalty or the constitutionality of the death penalty. And for example, here with less restrictive means to achieve the purpose, the court found that life imprisonment is a less restrictive means to achieve the same purpose as the death penalty. So the court case is still sort of the locus classicus and a very good precedent to see the application of Section 36 of the Constitution and the limitation analysis. So obviously, in terms of, I just wanted to highlight this to you as well. So you've got obviously the limitation clause, Section 36 of the Constitution, but we forget sometimes that some of the rights in the Constitution are limited through demarcations and special limitations. So some of the rights in the Bill of Rights are already textually qualified. If we think about Section 16, for example, and 17, and there's others as well, Section 16 deals with freedom of expression, and in Section 16(2), it states that the right in subsection 1 does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, etc. So already the right provides its own limitations. So if you, for example, if you, for example, propagate for war, you're not entitled to the protection that Section 16 offers, because the right itself already provides that limitation. There's also special limitations. It authorizes the state to make legislation or to engage in an activity which may have an impact on the right in question. So, for example, Section 22 guarantees the right of every citizen to choose their trade, occupation, and profession freely. However, in the next sentence, it is said the practice of a trade, occupation, or profession may be regulated by law And if you think about, for example, the attorney's profession, there are certain things that attorney cannot and cannot do. So that right is already limited through applicable and relevant legislation. So it's not only the limitation clause, section 36, that can limit rights, but some of our rights in the Constitution is already limited through the way in which they're phrased, known as demarcations, and then you also get special limitations where legislation exists that give effect to that fundamental right, which already limits its, which already provides limitation in that respect. All right, remedies. So we're moving quite fast. Is there any questions at the moment? Everybody still on board? Perfect. Then I'll just carry on. So as I've mentioned about remedies, and I'm just going to focus on constitutional remedies. So because we're dealing with constitutional litigation and with constitutional law practice, we are going to be focusing on the remedies from which flows from the Constitution and which then obviously flows from a direct application of the Bill of Rights. In terms of the Constitution, this is section 38 of the Constitution and section 172. And they should be distinguished from our ordinary legal remedies that would flow from an indirect application of the Bill of Rights. Because as I've mentioned in the beginning, if the Bill of Rights is applied indirectly, your remedy will not be a constitutional remedy, but your remedy will be in terms of the applicable piece of legislation or the relevant rule of common law. Section 38 of the Constitution provides for the enforcement of rights, and as you know, as I've mentioned already, that is the locus standi or the justiciability provision. But right at the beginning, it says anyone listed in this section has the right to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. So, but providing that phrase of appropriate relief, it means that when one of your rights in the Bill of Rights are infringed, that you are entitled to any of the relief that is available to our courts. So any of the normal relief is available to you, albeit an interdict. It specifically mentions a declaration of rights, all your admin law, labor law, all those remedies are available to you in terms of a right that's been infringed if it is a fundamental right. If it's a fundamental right, sorry. The other important section to keep in mind is the declaration of invalidity. But before I go there, I'm just quickly going to go over to the guide, and you'll see there I make reference on some other odd reason it doesn't want to go out. There we go. I make reference to page 61. So if you look at page 61 of your guide, there we are already on page 61, you'll see that the guide refers to a list of the remedies, and that's just to highlight that all the remedies are available to you: interdict, mandamus, damages, contempt of court, exclusion of evidence, admin and labor law remedies, development of the common law, cost awards, and then obviously also the possibility of a referral to a Chapter 9 institution or other relevant authorities. So the remedies are explained or discussed in the guide. So if you want any more information on those remedies, you're more than welcome to have a look in your guide there. But the most important aspect to know of remedies is that all the regular remedies are available, and then very important in terms of the Constitution in direct application is section 172, which is a declaration of invalidity. So when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. It may make an order that is just and equitable, including an order that limits the retrospective effect of the declaration of invalidity, any order suspending the declaration of invalidity for any period on any conditions to allow a competent authority to correct the defect. The SCA High Court may make an order of similar status concerning constitutionality of an act of the president, an act of the president, Parliament or conduct of the president, but an order has no force unless it's confirmed by the Crown Court, as we know, and a court which makes an order of constitutional invalidity may grant a temporary interdict or temporary relief to a party, or may adjourn the proceedings pending a decision of the Constitutional Court on their validity. Very important to keep in mind is that it's not a discretionary remedy. If something is unconstitutional, it's found to be unconstitutional, the court has to declare it as being invalid. So the declaration of invalidity is seen as a remedy, so it's the first remedy, but obviously you can't just declare something invalid and just leave it there. So a declaration of invalidity usually goes hand in hand with other remedial action. The section year before makes a mention of two of those. It's an order that limits the retrospective effect of the declaration of invalidity, and an order that also suspends the declaration of invalidity. That's also known as suspension. And in terms of limiting the retrospective application of such an order, you can obviously think of it so that it would be declared unconstitutional as from the date of the relevant judgment, and it would not be retrospectively applicable. Suspension, often when legislation is declared invalid, the court suspends the declaration of invalidity, basically to respect the separation of powers, and so it will often declare a piece of legislation as being unconstitutional. So that's your first remedy, the declaration of invalidity, and then it will give Parliament usually about 24 months to correct the relevant defect. Obviously, if a Parliament does not act within that prescribed period of time, the declaration of invalidity then comes to force, and then that specific section or act would then be invalid and no longer relevant. Usually Parliament acts within that time frame, obviously will then amend the relevant piece of legislation that corrects, obviously, the unconstitutionality. Also, in that extent that goes together with limiting the retrospective application and suspension is also severance or reading in. So law conduct is declared invalid to the extent of its inconsistency. A particular section can be declared invalid while the rest remains intact. So when legislation is declared invalid, you don't have to declare the whole piece of legislation or a whole section invalid. It might be only a particular part. It might also be possible to sever the bad from the good, and the remainder should still give effect to the purpose of the law. And obviously reading in goes hand in hand with severance. So, for example, if it is a specific word that is problematic in legislation, obviously we sever the word and we can read in a word in its stead. Okay, there's other forms of relief: interdicts, constitutional damages, contempt of court, exclusion of evidence, administrative law and labour law remedies. And I've just forgot to put the page number in there, but I've just mentioned that they're at the top, and it's actually page 61 of your guide that gives you reference to all of the relevant remedies that can be awarded. So in terms of remedies, do you have any questions or queries on remedies?
May I ask
Prof.
Yes,
I just want to know whether now the constitutionality of the legislation by the High Court, they can just do it without now referring it to the Constitutional Court for confirmation.
No, there still has to be confirmation. So the relevant court will declare it invalid. It would obviously suggest, invalid, provide the relevant relief, but then it's sent to the Constitutional Court for confirmation. Usually, the court can provide for interim relief whilst, the confirmation proceedings is taking place before the Constitutional Court. But yes, if we declare a piece of legislation or a specific section of legislation as being unconstitutional, for example, the High Court will declare it constitutional, suggest suspension or whatever the case might be, but it still needs to go to the Constitutional Court for confirmation. And obviously, the court can provide for interim relief as well, whilst awaiting the confirmation proceedings from the Constitutional Court as well. So anything that's declared unconstitutional still needs to go to the Constitutional Court for confirmation.
Prof, can I just interrupt?
Yes.
The Muslim marriages in the marriage law, we've just had it in our matrimonial legislation. That law that's regarding Muslim marriages, which was, they've declared that invalid, but they've suspended it until such time as Parliament changes it's got to go back to Parliament and they've got to change the legislation. Am I correct in understanding that?
I'm not specifically certain about the case, but yes, that's how it works. So if a piece of legislation is, or a section is declared as being invalid, that goes back to Parliament, and Parliament now, and they usually provide a time frame as well, and it's usually about 2 years. So they will say either 12 months or 24 months. So Parliament now has got 24 months in which it needs to amend the relevant legislation. Again, if the court provides that suspension, it can provide interim relief as protection. But yes, so it goes back to Parliament and Parliament must now correct.
Thank you.
Prof?
Yes.
Hi. Okay, I just wanted to extend on the question that has been asked. So in the meantime, what happens? Let me give you a scenario. Say you are a female who's married under the Muslim rights and under the Muslim Marriages Act, and you apply for family responsibility leave. Is the employer entitled, or rather, is the employer compelled to accept that you are actually married in terms of Muslim rights? Or can they say that the legislation has not been updated as yet, so we would need to reject it?
So obviously the courts would be providing you with interim relief, but within such a scenario, it would be to the detriment of the employer to refuse, because it would be an infringement of the relevant party. So it basically would be discriminatory against that relevant party for that fact. So I'm not exactly sure which sections was problematic in terms of the Muslim Marriages Act that was referred back, but obviously, and also you just need to read the order quite closely, because the courts can provide interim relief that is applicable while Parliament is busy amending the legislation.
Okay, that makes sense. Thank you.
Yes, there's another question.
No, it's not a question, maybe a comment on the question the colleague has raised. My view would be, remember, we have different sources of law, and case law is also a recognized source of law. So in relation to the matter regarding Muslim marriages, even though our current marriage legislations do not necessarily recognize Muslim marriages, but we do have case law. I think it was Women Legal Trust and versus the President of South Africa. So one can use that as a source of law, even though we do not have legislation. So if the employer refuses while there's case law, then the employer will be acting unlawfully. Thank you.
Yes, and as I've mentioned, it would be discriminatory as well. So and there is a lot of case law on that would provide the relevant relief in the interim as well. Any further questions before we move on?
Prof, I just want to check something here with regard to a matter of a legislation that has been invalidated by the Constitutional Court.
Yes.
And referred to Parliament, and Parliament being given a time frame of 2 years.
Yes.
Now, in 2 years or 24 months, yes, I just want to check, in an event that, such invalidity has not been dealt with by Parliament, and Parliament has not applied to court for extension. Well, I understand that you said the invalidity will come into force, but then will Parliament, can Parliament proceed and make amendments as per the judgment given by the Constitutional Court? Or it means that if there's nothing that is being done within that 2 years, then they cannot do anything. The only
Yes, so obviously
it comes into force.
So obviously they can approach the court for to extend the time period. But if they don't do anything, so if the court's not approached to extend the relevant time frame, the time frame in terms of which the legislation has to be promulgated, then that declaration of invalidity kicks in, and there is then nothing that they can do. Then what? Obviously, that relevant section would be invalid, and there's nothing to replace it with. Usually, Parliament does react, or usually Parliament does request an extension. But yes, if you don't act within the particular period of time, then the declaration of invalidity kicks in. So the main reason why suspension is allowed for, as I've mentioned, is to respect separation of powers and to grant the legislative branch a chance to remedy their defect.
Well, thanks, Prof. One last question. I just want to check: is it compulsory for the court to give a temporal or the court may decide not to give a temporal when dealing with the invalidity of a legislation that is being referred to Parliament?
Sorry, you broke up a bit, but as I understand, you asked, does the court have to give temporary relief when it gives a declaration of invalidity? And obviously, it's within the discretion of the court whether it would like to give temporary relief or not. So it's not forced to give temporary relief. It's within its own discretion whether it wants to give or not.
Thanks, bro.
It's a pleasure. All right, so let's carry on, and there's not much more to go through for this evening. I would just like to highlight in light of what we've discussed tonight that there is some important rules of the Constitutional Court that you can go have a look at. The Constitutional Court rules is obviously available on the Constitutional Court's website, which is very easily accessible. Important rules in terms of constitutional litigation, especially, is amicus curiae, which we'll have a quick look at. Rules in relation to urgency, which is Rules 12. Rule 16 is confirmation proceedings, as we've mentioned in terms of the relevant section as well. That's the rule that gives effect to it. Then Rule 18, which deals with direct access. Rules 19, appeals. Rule 20, procedure on appeals. And then Rule 31, documents to lodge to canvass factual material. And that actually goes hand in hand with Rule 10, which is amicus curiae. So I'm just going to stand still at one of these rules tonight, and that is amicus curiae. Amicus curiae is in Latin means friend of the court. It's direct translation, and it's very important in constitutional litigation. And you'll see lots of the Constitutional Court cases, if not most of them, have got submissions by amicus curiae, especially the cases that deals with the rights and the Bill of Rights. And the reason for this is...
Hello.
Yes.
Hello, ma'am. I just want to find out, is there a limitation on the amicus curiae in terms of joining the matter? Is there a limitation? And there's no limitation.
Okay, let's just, we're going to get there when we do the rule. I'm going to tell you now.
Okay.
In terms of how they can join, when they can join, and what the procedure is. So, and the reason why we allow amicus curiae, and obviously amicus curiae is also not only allowed in the Concord, but it's most prominent in the Concord, is because constitutional disputes have implications and effects beyond the immediate parties to the disputes. Interventions by interested parties are permitted in appropriate circumstances. They are regulated by Rule 16A of the Uniform Court Rules, Rule 16 of the Supreme Court of Appeal rules, and Rule 10 of the Constitutional Court rules. So we are just going to have a look at Rule 10 of the Concord rules, because it's actually the rule, the first rule that was introduced on the amicus curiae, and all of the other rules mostly mimic it. And as I've just said, they all permit the intervention by third parties on such terms and conditions as the relevant court allows. So it's important to keep in mind that amicus curiae interventions may have a significant consequence, and under very stringent conditions, they might even be permitted to introduce new evidence to the court. Okay, and now, as per your question, when are they allowed to be admitted? So where written consent has been obtained from all the parties, where consent has been obtained, an amicus will be admitted upon such terms and conditions and with such rights and privileges as agreed upon between the parties or as directed by the Chief Justice, or number 2, upon application to the Chief Justice. Now, if you see these two, it seems like they're two sort of separate requirements. So although the text suggests that admission can be sought with the consent of the parties or via the permission of the Chief Justice, the court has stated in the Basson case that the permission, that the court's permission is the only requirement pertaining to admission, so irrespective of the consent obtained by the parties. So whether the parties say yes to the amicus or whether the parties say no to the amicus, it's irrelevant. It's totally within the discretion of the court to admit an amicus curiae to participate. You'll find a lot of the time, especially in the very big cases and complicated cases, you'll find that the court and its directives, it will send a call out for specific parties to join amicus curiae or to bring to their attention that the court would like the input as amicus curiae. Sometimes, for example, if it relates to a gender matter, they might call on the Commission for Gender Equality to give their input. When it pertains to customary law, for the relevant traditional leaders to come and give input as amicus curiae. And if you look at the text of the Uniform Court Rule 16 Big A, if you read that rule, if you raise a constitutional issue in your papers, you have to put up a special notice in terms of Uniform Court Rule 16A. You've got to put up a special notice at court. There's a specific notice board that's dedicated in the high courts there too, which alerts people to the fact that you're raising a constitutional issue in your matter. And basically what that Rule 16A notice then does, it acts as an invite for amicus curiae to make them aware of the fact that here's a constitutional issue that's being litigated, and that if you want to obviously act as amicus curiae, that you should then obviously follow the procedure and the relevant rules of procedure in order to be admitted. So whenever a constitutional court issue is raised in court, you've got to put up that notice that basically acts as an invitation for amicus curiae to participate in the relevant matter. So in terms of Rule 10, an application by an for admission must be made within the time limits prescribed by the directions given, or no later than 5 days after the lodging of the respondent's written submissions or after the time for lodging such submissions has expired. And importantly, it has to engage 3 issues. It has to describe the interest of the amicus curiae in the proceedings. What would the position be that's adopted by the amicus curiae? And very important, it should set out the submissions to be advanced, its relevance, and the amicus curiae's reasons for believing that the submissions will be useful to the court and different from the submissions of the other party. That is very important. So you can't just piggyback on either the applicants or the respondents' pleadings, or go solely in to show, although you might show support for one of them, you can't just copy their arguments. You have to, through your amicus curiae application or intervention, you have to bring something relevant and new to the court. A lot of the time, what amicus curiae would bring to the court is additional research, additional information, or scholarly input on the relevant topic that's before the court. They have a right to lodge written argument, provided it does not repeat any matter set forth in the argument of the other parties and raises new contentions which might be useful to the court. Important is they are limited to the record on appeal unless the facts are common cause or otherwise incontrovertible or are of an official, scientific, technical or statistical nature capable of easy verification. And that basically
each other is dying water, children is dying water. This shutdown
just mute that individual. There we go. He's not mute. There you go. There we go. All right. So in those instances, so in other words, where it's of an official, scientific, technical or statistical nature, possible of easy verification, under those circumstances, obviously, you'll be able to introduce new evidence to the court. But again, the court is really strict on it and does not allow it very easily. The default position is that oral argument will not be presented, but usually the amicus curiae is invited by the court on the day when the relevant case is heard to present their arguments orally as well. A costs order may make provision for the payment of costs incurred by or as a result of the intervention of the amicus curiae. Therefore, an amicus curiae may be ordered to pay part of the costs, or costs may be awarded in its favour. But it's practice of the court to award no costs for or against the amicus curiae because of the assistance that it does provide to the court. And just remember, in constitutional litigation in general, costs work a bit differently in constitutional litigation. So usually we know that costs follow suit. So the successful party obviously gets party-to-party costs, but in constitutional litigation, it works different because the court do not want to, the courts do not want to hamper people exercising their rights or be too afraid to give effect to their constitutional rights. It usually means in constitutional litigation that each party is ordered to pay their own costs. So you might not necessarily be saddled with a cost order, but sometimes cost orders has been made against the state because of the fact where there is obviously a flagrant transgression of constitutional rights. But in relation to parties, the normal rule by the constitutional court is that each party pay their own costs in constitutional litigation. And that is the slides and constitutional law for this evening. And I'm going to open the floor up now for any questions that you might have.
Professor?
Yes.
Can the AC be applicant or defendant or respondent?
May the AC
be an applicant or a defendant?
No, the amicus curiae is a third party. It is not tied to the applicant or the respondent. So you can't, as an applicant, also enter as amicus curiae, or as the respondent also, apply as an amicus curiae. It's a third party. So does not have ties to either the applicant or the respondent.
Prof, I just want to check with it. No? I think there's one case. It's FOSA versus, is it Department of Education? Mm-hmm. So initially with that case, the matter was decided at High Court. So the matter relates to unbanning of beating of children at home. So initially the High Court decided that parents should not be beat up their kids.
Yes.
And then So FOSA, which is a religious organization, felt that their religious rights in relation to parents' right to chasten their children are infringed, and then they took the matter further.
Yes.
Wouldn't you say in such circumstances, because initially you would imagine that FOSA acted as amica, but then when they took the matter further for review in the next court, I think it was in the Concord, they then were an applicant in the matter. So in such a situation, what would you say?
Was Forsyth the applicant in the first matter, or was it an amicus curiae? Or who was the amicus curiae? Because I know there was a bunch of amicus curiae that participated in the matter, but weren't they the applicants in both the High Court, in the High Court and in the Con Court?
Prof?
Yes. Can you hear me?
Hi, Prof.
Hi, can you guys hear me?
Yes, while Kefas is still organizing himself, and I do have one question.
Okay.
For you. In an instance where the legislation is being invalidated, or it's in the process of being invalidated, what happens to the previous judgment or case law that came to the being while trying to give interpretation of that particular legislation?
So while it is going to the Constitutional Court for confirmation, what happens?
Yes,
in the interim.
Obviously, prior to that, there were judgments that were handed down in giving effect to that legislation. Will those judgments still stand?
So obviously, when a High Court or a Supreme Court of Appeal, makes a constitutional declaration of invalidity, they are well aware that their judgment needs to be sent to the Constitutional Court for confirmation. And in most instances,
okay. I'm not sure if your line was breaking.
Yes, Kathy, I'm just quickly answering the question. I'm going to get back to you just right now. So in most of those instances, the relevant court would provide for interim relief pending, obviously, the confirmation proceedings in either the SCA or the Constitutional Court.
So meaning that that temporary relief may even suspend the operation of those previous judgments?
The operation of which, so the High Court declares something as being unconstitutional, so it would provide interim relief in the interim whilst it goes to the Constitutional Court for confirmation.
I'm not sure if I'm following you correct, because obviously then there may have been previous judgment that were handed down in giving interpretation effect of that particular legislation that is being invalidated. And that's where my question lies, to say that, okay, will those previous judgment or case law still apply in the interim? Or will they also gonna be suspended?
Yes, no, I understand what you, so no. So obviously, if the High Court gives the judgment and it declares it invalid, so that is the judgment that will stand waiting for the confirmation from the Constitutional Court. So obviously that would be your precedent. So your precedent would be the latest judgment. So it would be the, let's say, the Supreme Court of Appeal makes a judgment. So it will invalid, obviously, that would be the precedent and the relevant precedent until it's confirmed by the Constitutional Court.
Thank you.
It's a pleasure. Have we lost Capheus? I think he might have.
I'm still here, Prof.
Are you still here? Okay, there we go. Yes, just repeat your question there that you had.
Are you able to hear me?
Yes, it was on the Forsyth case, and you asked about. I'm not exactly. I'm aware of generally aware of the facts of the case and the issues that was heard. But are you sure that the applicant became the amicus became an applicant?
Yes, I think if I recall the case, so here is what happened. There was one guy who found this child watching pornography.
Yes, I
then-
remember the facts of the case, but I can't remember exactly what the parties to the case were. As I understood, the applicant remained the applicant throughout, but there were different amicus that was involved in the case.
Yeah, if I recall, the thing is with the High Court, they then decided, because initially at the High Court it was a criminal case against the parent who beat up his child, and then so FOSA, on the basis, I think there's a scripture in the book of Proverbs that says you should not you should you should chasten your child, something along those lines. So because FOSA have interests insofar as religious rights are concerned, particularly Christian rights, they then took the matter to Concord, because one, the Concord needed to confirm the constitutional invalidity insofar as the common law rule of beating up children is concerned. So that was the first part that had to be done. But then the other part, FOSA also made a case to say the High Court had erred by declaring that section invalid. So they were a party. They were the main party when the matter went to Concord.
Yes, but remember that they weren't both amicus and applicant in the Concord decision then itself.
No, I thought the colleague who asked the question is whether an amicus could be an applicant at a later stage, if I understood him well. So the reason why I'm bringing up this issue is because even though at Concord they were not the amicus, but then they took it on the basis that in the High Court, I think they were the amicus. And then when it went to Concord, then they were the main applicant, defending Christian rights, yes.
Yes.
Or Christian beliefs.
Yes, but you can't be
It's a different
case. Yes, it's a different matter.
Different courts,
It's
different courts, different courts.
There we go. Exactly. There's a question in the chats. Can you explain the difference in severance from notional severance? So severance in that sense is a remedy, whilst notional severance is known as reading down, which is not a remedy, and it is a method of interpretation when interpreting. So it's notional severance. The other name for notional severance is reading down, which is a method of interpretation, whilst severance itself is a remedy. Is there? Yes.
No, sorry, you can first finish your explanation about the severance.
No, it's fine. I'm just saying that notional severance is reading down is the other words for it, and it's interpretation and not a remedy. But you're welcome to ask your question.
Thank you. I just wanted to ask you, can you maybe give an explanation of which type of remedies will be handed down by the court, interim relief that you referred to, while legislation is being invalidated? I just want to make sure, are those remedies that's referred to on page 61 of the study guide, or is that the remedies that you're referring to?
No, those are just the remedies that I'm referring to in terms of page 61 is the general remedies that can be awarded. But if we talk about an interim remedy that can be awarded, it will obviously be dependent on the relevant factual circumstances. But for example, the court might, feel that there is some interdict needed, or a mandamus or declaration of rights that's needed in the specific circumstances. So it will be dependent on the relevant factual scenario, what the legislation pertains to, and what would be, in the benefit of the relevant parties, waiting for the relevant, for Parliament to correct the relevant defect. So in that sense, they will award interim relief depending on the relevant factual scenario. But the remedies that's referred to in your guide on page 61 is just the general remedies that can be awarded in general in relation to any to any rights that's being vindicated in terms of the Constitution.
Okay, thank you so much.
It's a pleasure.
Prof?
Is there another question? Yes.
Yes, I just want to ask, Prof, when it comes to the High Court and a judgment on constitutional validity. Yes, Prof. So who confirms it's the Constitutional Court? I understand. Now the question is, who applies to the Constitutional Court for a confirmation? Is it the High Court or the parties in that particular case waiting for a confirmation from the Constitutional Court?
Yes, it's usually the parties, and I'm just quickly going to have a look if we can quickly have a look at that specific rule. So in terms of sending it for confirmation, you'll go according to what's prescribed in Rule 16 of the Constitutional Court rules, and that prescribes to you the process to be followed in terms of confirmation. So I'll just see if I can quickly draw down that rule for you, and then we can quickly just share the screen and have a look at the text of that relevant rule. I'm an amicus now, going for urgent applications, and there we've got confirmation. So I'm just quickly going to share my screen again. And then we can just quickly have a look at the text there. So this is Rule 16 of the Constitutional Court rules. The registrar of a court which has made an order of constitutional invalidity shall within 15 days of such an order lodge with the registrar of the court a copy of such order. So the court sends a copy of the judgment to the Constitutional Court. A person or organ of state entitled to do so and desirous of appealing against such an order of the Constitution shall within 15 days of the making of such an order lodge a notice of appeal with the registrar and a copy thereof. The appellant shall in such a notice of appeal set forth clearly the grounds. So that is the rule that you'll follow. So obviously, by reading the rule, it is the obligation of the relevant court to forward that the relevant judgment to for confirmation to the Constitutional Court, or if that judgment is being appealed, to follow to forward the relevant information through to the Con Court. So in terms of following the procedure for a declaration of invalidity, you look towards Rule 16 of the Constitutional Court rules.
All right, thank you, Prof, for that. And then I just want to ask again, when it comes to the amicus curiae, you mentioned something about costs. I just want to ask, since sometimes it's the court who will approach certain parties who might have interest in that particular case and might offer perhaps a very insightful view in that particular dispute. So on the question of cost, is it the court that perhaps puts the bill when it comes to the amicus curiae, or it's the parties involved?
No, it would be the amicus curiae themselves that would foot the bill in terms of costs. Remember that a lot of public interest law firms, the Chapter 9s, often jump at the opportunity to act as amicus curiae even upon the Constitutional Court's invitation, because it's very good exposure for them, and it is also, they could get very good traction from it. So it's usually not an issue in terms of having to pay their own costs. They are usually more than willing to, but no, the court doesn't foot the bill. The amicus curiae themselves have to foot the bill.
Okay, thank you, Prof. One last question. And then upon confirmation, the court, maybe the Constitutional Court differs with the judgment of the High Court and perhaps states that they add in their judgment. What happens, Prof? Is the decision reversed since a superior court has judged? And what happens to the parties if perhaps they've started a process of appealing that particular judgment?
So obviously the Constitutional Court is the court of final instance then. If the and also as we've just read the relevant rule as well, so obviously the court first needs to be informed as if there's any appeal against the judgment, because obviously the relevant appeal would first then go ahead before it's heard by the relevant constitutional court. But when the Constitutional Court differs from, let's say, the High Court or the Supreme Court of Appeal on a relevant finding, then obviously the Constitutional Court's finding would stand. So that would be then the President, and then the relevant Constitutional Court would provide the relief that it finds appropriate.
Thank you, Prof.
It's a pleasure. Is there still questions? I see there's a hand still of Godfrey Nisi. Godfrey.
Good evening, Prof. Yeah.
Good evening.
Yeah, my question is, at what stage of the litigation can the amicus curiae get involved? Whether maybe in the court of first instance, or maybe the Supreme Court of Appeal, or even the Constitutional Court, number one. The second question is, there's a general perception out there that, sometimes the courts are prone to manipulation, where certain parties may actually collude with, for instance, registrars and so on to choose and try to coincide with certain judges, who will actually rule in their favors. Are there any remedies in such instances? Thank you.
Okay, the first one, just remind me quickly, was on amicus curiae.
Yeah, at what stage can they get involved? Whether in the
Oh yes, on what stage can they get involved? So obviously amicus curiae is allowed to get involved at any stage in terms of the litigation of the High Court, either Supreme Court of Appeal or Concord. As I've mentioned, they're much more prominent in the Constitutional Court, but if a matter starts off at the High Court, and that's what I've mentioned about Rule 16a, it's a Constitutional Court matter, you put up the notice and a amicus curiae can get involved. And as per the usual rules, an amicus curiae files the application to get involved after the relevant heads of arguments of the respondent has been filed. So that is the point in which you file for your application to be admitted as amicus curiae. But yes, amicus curiae is allowed in all of the superior courts, as from High Court, Supreme Court of Appeal, and Constitutional Court. Sometimes you'll find matters where obviously there has been an amicus curiae in the High Court, and they follow obviously it through the process, and also would be the amicus curiae in the Constitutional Court as well. In relation to a remedy in terms of collusion of court personnel, in terms of choosing choosing certain judges that might be have a lenient ear towards their matters, there's no specific remedy, obviously, until it can be proven that something like that is being done, and obviously then a complaint or a case might be open, but there's not a specific remedy for those instances. So obviously you need to be able to prove it and then to lodge a case against those specific individuals, which obviously would be very difficult. But yes, there's no specific remedy.
Thank you very much, Prof.
There's a hand still up from Dion Anthony. Dion, do you still have a question? Yes.
Good evening, Prof. I don't have a question. I just want to make a comment.
Mm-hmm.
And I want to thank you because I'm a time management freak. So if people do respect my time by starting on time, 17:30, I have a lot of respect for those people. And I want to thank you for that, starting on time every time. Bye, dankie and mooi loop.
No, it's an absolute pleasure. I'm also like that. For me, time is money, and time is extremely precious to me. And I'm not in the business of wasting anybody's time as well. And that's why when we're finished with the lecture, we're finished as well. I don't like to try and stretch it out. I see a couple of other hands going up there. There's a Sifunda. Sifunda, do you have a question?
Yes, Prof. Prof, yes, I also just want to pass my gratitude and thanks to you. We really had a great time, and your patience with us, and the way you tackled our questions. You were quite open-minded and to the fact that we are learning, and never agitated at any point by the questions we were raising, even though sometimes they were repetitive, but you were eager to answer all of them. And one last thing, Prof, really thank you so much for the relief on our lectures when we ended early, and the time management was really awesome. So big ups to you, and thank you so much for the amazing time we had.
No, and thank you guys. I've really enjoyed the past couple of days as well. You've been a very nice group to teach, very interactive, and I've really enjoyed it. Is there any further questions, Ilani? Ilani, I see you've got your hand up.
Oh goodness, sorry, that's a mistake.
Okay, now have a good evening, Ilani.
Thank you.
Yes.
This is not a question. I just want, well, it is a question, but it's not really academically related. The right of appearance. Are there many attorneys who are arguing actively cases in the Constitutional Court who's got right of appearance, or do they all mostly brief advocates? I'm a 56-year-old. I'm finalizing my candidate attorneyship now, and my whole idea is to do a practice that deals specifically with constitutional, administrative law, and the rights, because my foundation is in immigration, and there's a lot of abuse in that area. So that is why I wanted to go into that area. I just leave it. You don't have to answer long. You can just answer shortly.
There's not a lot, but there surely is every now and again there is one. It's not general, but yes, it's absolutely a possibility. So I mean, if you've got your heart set on it, and you've got the relevant certificate, then you would be able to.
Thank you.
It's a pleasure. And Sipho Simon Msibi.
Thank you, Prof. You might have addressed this matter. Maybe I was half asleep. With regard to the
Hello, Sipho. Can you hear me still?
Unmute yourself, Sipho.
Sorry.
Yes, Sipho, you're muted.
Can the court apply the more than one remedy in one case?
Yes, it would be, yes, obviously more than one remedy would be applicable. There can be a declaration of rights coupled with another remedy. Obviously, a declaration of invalidity is a remedy in itself, and that can be coupled with another remedy. So yes, you don't just have to stick to one remedy, but there is obviously a possibility, depending on the relevant factual scenario, that there might be more than one relevant remedy that might be applicable. So you're not restricted to only one remedy. There can be more than one remedy, and in any matter for that, damages as well. Damages can go along with whatever remedy you provide. So yes, there can be more than one remedy.
Thank you, Prof.
It's a pleasure. Molema Makoro. Molema, do you have a question?
Yeah, sorry, ma'am. Good evening. My question is a quick one. The Constitutional Court once ruled that a president had violated the Constitution, but I mean, after that, nothing happened. So the question is, who is supposed to enforce a judgment like that from the Constitutional Court?
But which matter specific? Are you referring to a specific matter?
Yeah, it was a ruling by the Constitutional Court that one president, South African president, violated the Constitution. But what I'm saying is, after that ruling, nothing happened to the president. Like nothing. So the question is, if the Constitutional Court makes judgments like those, what should happen to them?
But yes, but I'm not specifically sure what matter you are referring to, or the specific remedy that was provided by the court. But remember, the court has to walk a very fine line as well, in relation to the separation of powers.
Yes.
So the court has to constantly be aware of the fact that it can't, tread on the legislature's toes, or especially the executives as well. So the court can make an order, as it can make with, an order and provide a remedy, but in terms of giving effect to that remedy might be dependent on another branch of another branch in terms of the separation of powers, which might be problematic. So unfortunately, our courts cannot solve all of our problems. They can make the judgment, but whether that judgment is given effect to or enforced by the other branches of government is another story.
Yeah, no, okay. Thanks.
It's a pleasure. Zandile, do you have a question?
Yes, Prof.
Yes, Zandile.
Prof.
Sorry.
Yes, Prof.
I have a question. I wanted to add to the gentleman's question regarding the Please Call Me case, where the Constitutional Court ruled out that Vodacom needs to sit down with the applicant. Yes. So I just wanted to find out, in that instance, what can be further done?
In terms of giving or enforcing Vodacom to give effect to the judgment, well,
yes,
it would be dependent. I know that litigation has been ongoing for quite some time, and there's different aspect that's being debated. But yes, unfortunately, I mean, the court can gives a judgment, and obviously whether the other part, so the court would have to be approached again in terms of enforcing the relevant court order. That would be the route of the relevant party. So it is dependent on so the court gives the order, and whether it's enforced or not depends on who has to give effect to that. If it's not, the party obviously needs to approach the court again. And unfortunately, we know with that litigation, it's been ongoing for quite some time. Is there any other specific questions addressing the course content that you'd like to ask? I'm going to take the last few questions with the last couple of hands that's up. Let me just quickly get to, I think, Zandile, do you still have a question?
Prof?
Yes.
What happened in a case where the court have given a cost order and maybe the losing party is not able to pay it?
Then obviously the sheriff needs to be sent out in terms of you can enforce the cost order, and obviously you enforce the cost order in relation to the sheriff. So if a cost order is not given effect to, obviously the sheriff gets called in, and you execute the relevant order.
So what happens when the person who's supposed to pay the cost doesn't have the money to pay it?
Well, that's the unfortunate thing. If there's no movable or immovable property to sell, and if there's no money, then unfortunately you won't be able to get anything.
Okay, thank you, Prof.
It's a pleasure. Anele?
Yeah, ma'am, just to add on to what the previous question was asking. As we're having parties like a credit bureau, another way of punishing a person who doesn't or who cannot afford to pay his dues, he can be put in a credit bureau to be punished that he doesn't get credit for a period of certain time.
Yes,
Thank
blacklisted. So you can follow the normal course of action in that regard. Capheus?
Okay, thank you very much, Prof. Mine is a comment, not the question. One, I noted one colleague who raised a question about one court order that was given to the president. I suppose he possibly might be referring to President Zuma in the EFF versus Speaker case, unless if there's another case. But in that case, what happened is the ConCourt gave an order to say the remedies of the public protector are binding, and that is why we have the Zondo Commission. So for me, by having a Zondo Commission, that means that the court order has been executed, because you would remember President Zuma seemed to have an issue in having or implementing the remedial action proposed by Advocate Madonsela then. But then after the Concord decision in the EFF visa speaker, then we later had the Zondo commission. And then the other one, Prof, relates to concerns about colluding between registrars and certain officials of the court or judicial officers. So I think for me, we just need to remember, as future legal practitioners or candidates, as it were right now, to say, if you are not happy with a decision of a specific court, you have remedy, you can apply for review, you can take the matter for appeal, and then until the matter reaches the Concord. And even when you are not happy with the decision of the Concord, you also have an option. I think we should have learned from the recent, I think it was in relation to what President Zuma did when he was not happy with the decision of the Concord. He took the matter for variation in terms of section 42 of the High Court rules. So if indeed you are not happy even with the Concord decision, we still have an option, and that is to apply for variation. So those are the options that we have. And if everything fails, we just have to abide by the final decision of the Concord. Thank you.
Yes, and also, but it depends of how deep your client's pockets is. So I'm going to take the last two questions, which is Kaifias and Bahare. Kaifias, your last question there?
No, I just raised my point.
Okay.
That was
okay,
sorry,
then
Prof.
it's
Sorry, Prof.
Bahare.
Sorry, Prof. Anel, I didn't have a chance to pose my question.
Yes.
My question relates to Section 172, subsection 2B of the Constitution.
Yes.
Yes, there it talks about the order of constitutional invalidity, that a court can make an order of constitutional invalidity, making an order of constitutional invalidity may grant a temporary interdict or other temporary relief to the party. So this question relates to the Western Cape High Court that made a decision that the public protector can return to the office, but the Office of Public Protector refused to comply with that order. So can you please explain what entails that temporary relief, and also what grounds can the other party refuse to comply with that interim or temporary relief? Thank you.
In terms of temporary relief, that's just as I've stated. So with the declaration of invalidity or the suspension, so the court may grant any temporary relief that it finds is suitable. For example, whilst it's whilst the suspension is we're waiting for the legislature, so it provides the courts with the option of providing any temporary relief that it might find necessary. But obviously, in terms of refusal to comply with the court order, is you just need to approach the court again to get that court order enforced. I'm again not too sure about the relevant factual scenario of that case, but obviously, if it is a court order and it is standing, then you can obviously apply to have that court order enforced.
Also, Prof, that case that the gentleman is talking about, I think it is waiting for a confirmation order from the Constitutional Court, because it had to do with the unconstitutional conduct of the president.
Yes. So in other words, the court provided interim or temporary relief in that specific instance. So as I've mentioned before, usually when there is confirmation proceedings or suspension, temporary relief can be provided by the courts. The last question from Bahari Kekana.
Thank you, Prof, and good evening. I've got two questions, or two and a half. My interest is on rescission or rescinding application at the Concord. What I saw two applications going for rescission application at Concord, and they fell on the stomach. What does the court look into, especially at the level of Concord? What does the court look into when you make a recession application at that level? And another question, it's regarding the AC. Normally, I have noticed that only institutions or organizations are going there as AC. Can you go to AC as an individual? And my last question is around, can you be an AC at magistrate court or regional court? Thank you very much.
Okay, thank you. On the rescission, I must admit I'm not too sure, and also I'm not too sure what factors they would be looking at, as I would first need have to go and look at the specific cases. But in terms of amicus curiae, you can, if you want to, as amicus curiae as an individual, you're more than welcome to. But obviously, you need to comply with the relevant rules in terms of showing what your interest is, what you will be able to bring to the court, and obviously. For an individual to act as an amicus curiae at the higher court levels, obviously it would be very expensive to do so, and you'll find that it's usually organizations, it's usually public interest law firms, etc., that do act as amicus curiae because it is such an expensive exercise. But if you really feel like it, you can. But you just have to see to it that you comply with the relevant rules and that you're able to bring something to the court that it would find useful. I see that there's a lot of general questions. Is there any specific questions pertaining to the work? Otherwise, I'm going to cut you short because we've promised that we're going to end a bit earlier. Is there specific? I see there's still three questions. So these are the last questions that I'm going to allow. It's from Cafius and then still from Mr. Kekana. So Cafius, do you still have a question?
No, it's not a question, Prof. It's a comment on the question that the colleague has raised here. So in terms of the question, recession or variation, look at section 42 of the High Court rules. It deals with recession or variation application. One of the issues that's being looked at, it's if the decision of the Concord or whatever court that may have made the decision could have been ambiguous. So if I recall, there are actually about 3 grounds upon which you can apply for rescission. The one that comes to my head now, it's ambiguity. So, but you can just go through the High Court rules and look at section 43. It lists those 3 grounds. Thank you.
Okay, perfect. And thank you so much. And then I would just like to again say thank you for everybody for the last 3 days. It's been a real pleasure to teach you. And I really hope that all of your board exams go really well and that you're all admitted as attorneys soon and that I'll see you practicing in our courts. So yes, and good. So much luck with the rest of the courts and hang in there. You will definitely get there. And thank you so much for this platform. Have a very good evening. It's a bit early, so go and enjoy it with your families. Keep well, everybody.
Thank you, Prof.
Thank you.
Good night.
so much, Amanda.
Thank you, bye.
Thank you
Thank
so
you,
much.
Prof.
Good night.
Thank you.
Thank you.
Thank you, Prof.
Thank you. Bye.
Thank you, Prof.
$50 with ANC. It's good enough for most music, though I mean can't really compare to the higher ones, you know, like the Sonys or the Bose. It's you can't really compare with those. Now, when it comes to watching videos with the Budspeed Pro on YouTube and Netflix, it's good, nice. There's no audio delay, which is very important. Right now, for gaming, I would say that even though Xiaomi actually advertised the latency to be around 69 milliseconds, personally, even though I'm actually a casual gamer, I would still say that I won't recommend the Budspeed Pro for gaming because the sound effect audio delay is pretty obvious when you're gaming. All right, that's like a half a second delay. All right, so I won't really recommend the Budspeed Pro for gaming. I mean, for music, video, movies, perfectly fine. But for gaming, no, that's a no for me. And of course, finally, as I mentioned at the beginning of the video, I'll be including a variety of audio clips to demonstrate the audio quality of the microphone. All right, so remember to put your earbuds on. This is how your voice will sound like on the iPhone 12 mini. This is how your voice will sound like on the iPhone 12 mini. Testing, 1, 2, 3. Testing, 1, 2, 3. This is the mic test on the Redmi 5. This is the mic test on the Redmi 5. I'm using a coffee shop. I'm using a coffee shop. Testing, 1, 2, 3. Testing, 1, 2, 3. This is the mic test on the viewing and the people. This is on viewing. Testing, 1, 2, 3. 1, 2, 3. The mic test on the main Budspeed Pro. This is a mic test on the Redmi Budspeed Pro. I'm currently walking outside. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. This is a mic test on the Budspeed Pro. This is a mic test on the Redmi Budspeed Pro. Finally walking to a park. Some wind over here. So let's see if you can actually hear me very clearly. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. This is a mic test on the Redmi Budspeed Pro. Currently, it's at the sensor. It's a mic test on the Budspeed Pro. Currently, at the sensor. It is on. Testing, 1, 2, 3. Testing, 1, 2, 3. This is a mic test on the Redmi Budspeed Pro. I'm currently in a coffee shop with transparency mode. I'm currently in a coffee shop with transparency mode. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. Testing, 1, 2, 3. Go. Now, all right, finally, we have come to the one most important question is it worth it to get the Redmi Budspeed Pro? or should you get something else? I mean, well, for a pair of wireless earbuds, I mean, firstly, it looks great actually. I can't deny that. But it looks great. It has ANC, it has transparency mode, it has wireless Qi charging, dual device or multi-device connection and switching. Not only that, but it's at $50 US. I mean, for me, this is a great option, and it's actually a good investment in this category. $50 US with ANC, with transparency, it's wireless, it lasts for like 5.5 to 6 hours on a single charge. Battery take give you an additional 22 hours or even more, maybe even up to 30 hours, depending on your volume output. And not only that, it actually allows me, an iPhone user, to use it on a regular basis, right? So I personally feel that this is worthwhile to get it. I would even go further to claim that, the Redmi Buds 3 Pro is the new king of budget ANC wireless earbuds. All right, and there you have it. This is actually my personal review of the Redmi Buds 3 Pro, and I hope that my sharing has actually helped you. I mean, if it did, it'd be great if you could actually smash the like button, subscribe to my channel if you haven't, and if you feel that this is a very good content to share with your friends, please share with as many friends.
All right, guys. So today we're checking out the Soundcore Life.3 app. Now, this is a very interesting pair of earbuds. What makes it interesting is I think this is a really good, affordable option compared to the Liberty 3 Pros, which come in at $169, where the Life.3 eyes come in at only $59. But what's going to make this a little more difficult is these are harder to find than the Liberty 3 Pros. In fact, the only place that I can find these are in a Walmart physical store, or they're on Walmart website. So I am going to have a link to that in the description below. But we're going to talk about all of the features that these have. We're going to talk about what all comes inside the box and the sound, and see why I think this is an incredible alternative to the Liberty 3 Pro. So to start with, these obviously have active noise canceling and transparency, and this is already what makes these compete with the Liberty 3 Pros. But the ANC and the transparency mode is not on the same level as the Liberty 3 Pros, and that's kind of to be expected, I guess, because of the price tag. But I felt like the noise canceling was still very good, especially against lower tones. So if you're going to be somebody that travels where you want to dull out the plane or the engine noise of the car, these do an excellent job with that. It's just when people are talking, or if there's anything with a higher pitched tone, those sounds still come in. But the transparency mode on here, I feel, worked really well. I was able to hear my surroundings. There is a slight digital noise for the microphone, but I was still easily able to carry on a conversation without actually taking the earbuds out. Now, the features and specs, these do use 10mm graphics drop. It does work with Soundcore's app, so that's already a huge plus. It can give you about 22 different EQ settings, but you can also go in and customize the EQ settings the way that you want. You can switch around the controls if you want, and this also allows Soundcore to keep the earbuds up. So already, again, a huge plus of these work with Soundcore app. Now, as far as these outdoors, they do come in with an IPX5 rating, which means they're going to be fine against splashes and rain and sweat and things like that. But this is not one of those pairs that you could submerge into water. Now, as far as all that included inside the box, you do get the usual small, medium, and large silicone ear tip. Now, it does have a cable that you're going to have to keep up with because given the price, again, this is kind of to be expected. These do not have Qi wireless charging, so you can't drop them on any wireless charger. So do keep that in mind. Now, speaking of the charging, battery life, I was very impressed with on this pair because if you use these with the noise canceling off, you're going to get about 9 hours on the earbud, around 36 hours using the case. But if you decide to use these with the noise canceling on, it does bring the battery life down quite a bit because then you're only able to get about 6 hours on the earbud with around 24 hours. Using the case. But one feature this pair does have is if you do happen to get to charge your earbuds, you pick them up in their desk. There is a fast charge feature with a 10-minute charge, getting about 2 hours use. And again, I've said this before, this always comes in handy, especially somebody like me, where I'm not good about making sure my case or my earbuds are all charged. So now moving over to looking at the case and the earbuds themselves. Both of these are pretty small, very compact. In fact, the case on the bottom, you can see the USB-C input and the pairing button. And then around on the front, you have a single indicator light. This allows you to just gauge how much battery life is left. Hey, but when you open up the lid, this is the first time I've designed like these from Soundcore. I actually like the way that they designed them because designed in a way to fit your ear really nicely and kind of sit flush where you can actually lay down on a pillow and not feel like they're jamming into your ear. And another thing that I like about these is they decided to stick with using a physical button instead of touch control. And I'm also happy to say that they give you control over everything, or at least once you go in and switch around some things in the app to be able to control everything. But then once you do that, you have your play, your pause, your ability to skip your tracks forward, go backward, you have your volume control. Then you can also switch these into transparency or noise canceling mode, all from the earbuds itself. Now, for you guys that do like to use your earbuds for phone calls, these are using 4 microphones. They're also using what Soundcore is causing AI enhancement, which is basically causing the mic to focus on your voice and try to block out some of your surroundings. And I think they did an okay job here, but you guys